37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2023-2553 DM, Lindsay Moore versus Randall Moore. Today is Monday, December 18th, 2023 at 9:26 a.m.
Court will note the appearance of Ms. McNiff on behalf of the defendant. This matter is before the court on the defendant's notice for entry of order of temporary custody, support, etc. Ms. McNiff.
Your Honor, Mr. Todd and I had difficulties in coming to an agreement with regard to the amount of child support, but now we have an agreement. However, it took us more than 7 days to get to that agreement. I received an email this morning from Mr. Todd indicating that he was not objecting to the current orders.
Okay. Ms. Moore, are you aware that your attorney is not objecting to the current orders?
I am.
Okay, so there's no dispute that you have at this time? Okay, court will enter the order as submitted by Ms. McNiff. That will conclude this matter at 9:26 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
Yep, stay on, Lisa. I'm calling.
Okay.
Next case is Johnson v. Johnson. Mike, does your client plan on appearing this morning?
No, he does not.
All right. Kelly, can you hear me? Calling case 2023-1914 DM, Kelly Johnson versus Jeremy Johnson. Today is Monday, December 18th, 2023 at 9:28 a.m.
Good morning to everyone.
Morning, Your Honor.
Good morning.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff, Mr. Toca on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time support to extend discovery and mediation. Mr. Toth has filed an answer. I have reviewed all of the pleadings in this matter. Anything else to add, Ms. McNiff?
Your Honor, I would just state that I don't believe that we have an agreement on the counselor. My client attempted counseling with a counselor that she chose, and Mr. Johnson didn't show at that counseling appointment that he chose a counselor. I think that we need a neutral counselor. I've talked to Mr. Toth about possibly going with Margaret Hunter in Kalamazoo because she does specialize in reunification counseling, and she's been getting these cases done in a very quick timeline. Mr. Toth wasn't crazy about that idea, but I do think we need somebody who has some experience with reunification counseling.
Okay.
That's the main issue. As far as discovery is concerned, if I could just have another 2 weeks to send some subpoenas out, that would be very helpful. I think then we could still maintain the mediation date. But there are some, I do have some bank account statements that Mr. Toth has sent to me, but there's some additional information that I would like to be able to get. As the court knows, I got in very late into this case, and so we're kind of up against the clock. But if I could have that additional time, I think I could get what I need in order to attend the mediation on the 25th. And then the last issue, really, we don't have any order with regard to custody and parenting time. I believe that we should have at least joint legal custody. My client should have at a minimum standard parenting time. Child support, Mr. Toth is asking that it be set back from the date of separation. Mr. Toth knows that we can't go retroactive on child support. However, my client does understand that she needs to support the children, and we would ask that support be commenced as of today's date.
Okay, thank you. Mr. Toth, why are you being unreasonable and not giving Ms. McNiff another two weeks for discovery?
Your Honor, if provided that we preserve our mediation date, I have no objection to discovery being extended for 14 days.
Okay.
So that would be number one. Number two, Your Honor, I have no objection to a temporary order for joint legal custody. And I would further concede that With joint legal custody, both parties need to agree, or should agree on who's going to be doing the reunification therapy. So if the plaintiff does not agree with Suzanne Warren of continuing that process, then I would have no objection to it being administered by Margaret Hunter. Number 3, child support, if it's going to be established, should certainly be retroactive to the date of the filing of the complaint. The minor children have been exclusively with my client, Your Honor. Your Honor, I think it would be further inappropriate to establish a temporary parenting time schedule until we have an opportunity to have a hearing. There's a terrific amount or a terrific disparity between the positions of the parties as to what's happening. And it would even go as far as to include where the plaintiff's living. My client believes that the client has been living in Bellevue with her boyfriend. The parties have been separated for 6 months, Your Honor, and there's been no overnight parenting time. It's only gotten more and more difficult. The relationship between the parties is not good. The relationship between the mother and the children is extraordinarily strained, Your Honor. And I believe that the oldest child is now 17 years of age. He's having a terrific struggle with this entire situation. So, Your Honor, I think it would be inappropriate to establish any type of a schedule until we've had a hearing. The status quo ought to be maintained. If the boys will go with their mother, great, but there's been no overnight, and this is the first time that this matter has been brought to the court's attention. The status quo should be maintained. Hopefully this issue can be ironed out at mediation, and my experience with Margaret Hunter is she's very adept at making recommendations for a phased-in reunification schedule, and I think it would be most appropriate if the court is going to enter an order that would identify that the schedule progress according to the recommendation of Margaret Hunter on a temporary basis.
Okay. Anything else, Ms. McNiff?
Your Honor, I would say that there should be some parenting time, even if it's not overnight, even if it's not, for a week at a time. There should be some. There's no indication that my client is abusive to the children or neglectful of the children. We could stipulate that she would have all parenting time without any romantic partner. She could have parenting time strictly at her sister's home, which would be an appropriate place to do that. It is the holidays. It would be reasonable for her to be able to see the children for some period of time.
Okay. Mr. Toth, do you have any issues with that if it's more limited and again, it's not in the home where her partner is there?
No, I think that would be appropriate, Your Honor. The concern that I would have is these boys simply are not prepared to go spend overnight time with their mother presently. It's taken 6 months to get here, and I don't think that in one day we're going to be able to change their attitude. And we're certainly not looking to set a situation up where my client's going to be in contempt of a court's order.
Okay. Well, what we'll do is in this matter, again, it's been agreed upon a couple things that we would extend the discovery for an additional 2 weeks. So we'll do that. Also agreed that we'll utilize Margaret Hunter for the counseling. So that can be included in the order as well. There is agreement as to joint legal custody, and court will grant to the defendant physical custody in this matter. I am going to, as a result of the holidays, et cetera, I am going to provide plaintiff with some parenting time in this matter basically on the alternating holidays, but that would be for a period of, again, 5 hours from 12 o'clock noon to 5 o'clock p.m. And that she would have alternating Saturdays for the same time from 12 noon to 5 o'clock p.m. until such time as Ms. Hunter can make a recommendation, and then we can evaluate it at that time. Court will, again, set support in place, but I'm not going to take it back to the retroactive to the date of the complaint. I'll take it to the date of notice of plaintiff's motion in this matter. So whatever date that you sent that out and had proof of service on, Ms. McNiff, add 5 days for notice, and then we'll take it from that date, and she'll be required to pay whatever the guidelines require.
Will do.
Anything else, Ms. McNiff?
No, sir.
Mr. Toth?
No, Your Honor.
Okay, thank you all. Do I need to designate who's going to get Christmas Eve and Christmas Day, or the alternate, or what?
The kids are in Florida right now, and I don't know if they're coming back prior to Christmas. My client may know.
Do you know, Mr. Toth?
I'm not certain, Your Honor. I can find out. What I can represent, Your Honor, is that I would hope that Ms. McNiff and I can, once we get what the schedule is, that we can work it out. And
Well, attempt to do that. And I guess I'd say if the kids are gone and they weren't going to be back on Christmas Eve or Christmas Day, then what we could do is then give the plaintiff New Year's Eve and New Year's Day for the same 5 hours each day, and then alternate thereafter. But maybe you can come up with some sort of a better arrangement, then that would work as well.
very good.
Thank you,
Okay.
Your Honor.
Thank you, Your Honor.
Am I hanging around for my next?
Yes.
Okay.
The next case is Sloan v. Sloan.
And my clients are in my office, but they're in a separate office from me.
Yes, I see that. Attorney Podolsky. I'll bring someone in, I'm not sure who this is. Kelly, is your client appearing this morning?
Yes, that's her right there, Brandy Benson.
Is Steve Parks on this case?
No.
Not sure if your client knows how to.
Oh. He may not. Let me have somebody go real quickly and
Okay.
can you go start their video and their audio? I don't think they know how to do it. My assistant is going to turn them on.
I'll call the case. Calling case 2020-1968 DZ Timothy Sloan versus Brandy Sloan. Today is Monday, December 18th, 2023 at 9:38 a.m.
Court will note the appearance of Ms. McNiff on behalf of the plaintiffs and Ms. Podolsky on behalf of the defendant. This matter is before the court on the plaintiff's motion to enforce grandparenting visitation time. Ms. McNiff.
Your Honor, after reviewing Ms. Podolsky's answer, it seems that the parties are at extreme odds in terms of their perspective on this matter. And my thought is perhaps we do send everybody back to Suzanne Warren and then set up for an evidentiary hearing in order to sort out some of these issues where the parties are at extreme polar opposites.
Okay, Ms. Podolsky, what do you think about that proposal?
We have no issue sending the matter back to Susanna Warren. As the court's aware, that is what the current order says when there is a dispute. It's also what we requested. I don't believe an evidentiary hearing at this time would be necessary. These parties were perfectly capable working with Susanna in the past to craft this order, and I think they will be able to get through their issues, these current issues. And that's what my client's been trying to do. So I don't think an evidentiary hearing would be necessary, but absolutely a referral back to Susanna Warren.
Okay, the court will refer the matter back to Susanna Warren for additional, counseling and additional recommendation in this particular matter. I will, I guess, at that time state in the event that the parties are not in agreement with the recommendation, then they can file to seek a evidentiary hearing as to any disputed matters at that particular time. I will state at this point, until that happens, the court simply will enforce its orders, and those orders still remain in full force and effect. And then we will address that after Ms. Warren has an opportunity to reassess the case. Okay, Ms. McNiff, you can prepare that order to send the matter back.
Thank you, Your Honor.
Okay, thank you all. The court will end this matter at 9:41.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Monday, December 18th, 2023 at 8:31 a.m.
Good morning, Mr. Chapman.
Good morning, Your Honor.
You can proceed when you're ready.
Thank you. Before the court is Brianna Spears of case 16687 DS. Ms. Spears is here today after failing to appear before this court on November 1st, 2023. Bond is currently set at $1,419. This is the 6th bench warrant. Front of the court is unaware of any current employment. Last payment made on this case was on November 15th of 2023. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on December 27th, 2023 at 8:45 a.m. before this court.
Ms. Spears, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on December 27, 2023 at 8:45 a.m. Are you able to post a bond, ma'am?
The only amount of money that I have is in my personal effects, and that's like $50.
Are you currently working?
I just got a job at Riverside Country Club. I was actually supposed to be there today to fill out pre-employment paperwork.
Well, what I'm going to do is I am going to reduce your bond in hopes that you could be out of jail. What I'm going to do, I'm going to reduce your bond. I'm going to reduce it to $100. If you're able to post that, you'll be able to be released. Do you have any questions?
Nope, no question, Your Honor.
Okay, thank you. You have a good day.
Thank you, you too.
Anything else, Mr. Chapman?
I have some matters for the record here, if I may.
Yeah, go ahead.
Anthony Veltri of case 22667 DS. Justin Parker of case 02620 DS. Anton Lake of case 071797 DS. Joshua Rudd of case 23197 DP. Najee Frederick of case 113300 DS. And Kayla Burgess of case 223019 DC. These respondents failed to appear for their referee hearings. Front of the court requests that bench warrants issue in each of these matters pursuant to statute.
Court would enter a bench warrant for Mr. Veltri, Mr. Parker, Mr. Lake, Mr. Rudd, Mr. Frederick, and Ms. Burgess as a result of their failure to appear at their respective referee hearings. Court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater. And further, the court would assess court costs of $150 in each case.
I also have Quanchia Dupree Lee of case 2159. And I think the suffix is DS on it. I didn't write that one down. And case 17907 DS Marcus Ivy. In these two matters, bench warrants were previously requested after their failure to appear. But recent information has come in and now we're requesting that the bench warrant request be canceled and the matters dismissed.
Okay. Court will vacate the bench warrants on Mr. Dupree Lee and Mr. Ivy in this matter having been previously entered, and will dismiss those actions.
Thank you, Your Honor.
Okay, thank you. Have a good day.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2009-2018 DM Rebecca Sanford versus Scott Sanford. Today is Monday, December 18th, 2023 at 8:57 a.m.
Good morning to both of you.
Morning, Your Honor.
Good morning.
Court will note that this matter is before the court on the plaintiff's motion to show cause in this matter. The defendant has filed a response and the court has reviewed that. Ms. Sanford, anything else you'd like to add other than in your motion?
No, Your Honor, I think the court has benefit of all of the paperwork, and since you've reviewed that, no.
Okay. And sir, do you have anything else in addition to and other than your motion or your answer?
What, Judge, I just to ask if the court received my supplemental answer to her reply.
Yes, we did.
Judge, I would just indicate that back in 2018, 2018, we were trying to determine the credits that I was entitled to and when she was going to make arrangements to refinance the house, and she walked away from that process, and I haven't heard anything for 4 years.
Okay.
And now apparently she believes that that she doesn't have a duty to comply with the terms of the judgment because my debt was somehow discharged in bankruptcy. But I attached to the court that this was on my credit report till the middle of 2022, and apparently a new mortgage company bought the note. I don't know how else they would get access to it, so there must still be a note. And as I've always indicated, I always paid this mortgage outside of the bankruptcy plan, so I don't understand the issue.
Okay. Well, obviously the court notes in reviewing the pleadings that there are various disputes in the case, and court feels we're going to have an evidentiary hearing to ferret out what's happened. I will tell both of you that the court will simply enforce the judgment of divorce and the orders that have already been entered in this matter. I won't attempt to interpret the judgment of the orders. I'm simply going to enforce those. I note defendant had raised some issues about monies owed for groceries or something of that nature, states that there is no need. I'm not going to get into the need or all that. I'm just going to get into what do the orders and the judgment state, and then we'll get compliance with that. So we'll get in touch with both of you and see when you're available, and we'll set an evidentiary hearing and we'll get the matter concluded.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
Thank you. We'll be in touch in the next couple days.
Okay, thank you, Your Honor.
Thank you.
Next case is Toca versus Toca. Judge, or I'm sorry, Tom, is your client with you?
She is.
All right, calling case 2015-1447 DS, Alexis Toca versus Christopher Toca. Today is Monday, December 18th, 2023 at 9:01 a.m.
Good morning to everyone.
Good morning.
Good morning.
Court will note the appearance of Mr. Schaefer on behalf of the plaintiff, Ms. Elaine on behalf of the defendant. The matter is before the court on the plaintiff's motion to show cause. I note in reviewing the answer, Mr. Schaefer, that Ms. Elaine had stated that in fact that the arrearage in this case had been paid off. Have you were able to confirm that?
It was paid off as of November 24th. We confirmed that it got paid off on that particular date.
Okay, so that's a moot point at this time.
I think so, Your Honor. Yes.
Okay. What we'll do in this matter, I do note as well that Ms. Elaine had brought up the issue of the counseling, and again, that had happened years ago in this particular matter. It's my understanding that that may be a moot point as well. Have there been any new attempts at counseling since this court was involved, Mr. Schaefer?
I don't believe so, Your Honor. There have not been I mean, there's a tortured history of that back when, and we have gone back on so many different things on support and parenting time, and we still have parenting time and custody pending, and another show cause in relation to the parenting time. And this was all amalgamated together back when, and during the testimony, it is clear that, and admittedly so, that there was a violation of the order of joint custody, and that is why we are bringing it at this point in time, just because it's an ongoing, from our perspective, an ongoing harassment that needs to be held in check, and I think it needs to be reviewed.
Well, this court had obviously had a hearing in this matter, quite extensive hearing that we concluded with an order of September 25, 2023. I will let the parties know I'm not going to go into any other matters that predate that order of September 25, 2023. So if in fact the court would allow a evidentiary hearing, because we have a lot of other claims I guess floating around, but I'm not going to go back prior to the September 25, 2023. So I'm only going to take up matters at an evidentiary hearing that post date that particular order. So we will contact both of you and see when you're available and when we can set up hearing to resolve the other, I guess, pending claims in this matter. But so both of you know, I'm not going back to anything prior to that September 25 order.
Your Honor, to my knowledge, there aren't any other pending matters that aren't currently scheduled. Do you have a different understanding?
No, I just know that we've had so many motions filed and so many other things. I just want to make clear that I'm not going to go back prior to that date. So if that resolves everything else that we have, then we won't need an evidentiary hearing. So, but I'll leave that up to the two of you.
I think that's a fair analysis. I think everything else is scheduled, Your Honor.
Okay. Okay.
Your Honor, if I may, especially based on opposing counsel's responses to your questions today, I do think this is appropriate for an attorney fee award for the reasons stated in our motion. I think it can't be more clear that Ms. Toca is doing this as a retaliatory measure, and Mr. Schaefer today is not offering any legal argument to support the allegations that were brought. And I do think the court should put a stop to that and send a message that it's not going to entertain its judicial position to hear retaliatory motions brought years after an alleged event occurred.
Well, I don't know.
I'll be happy to respond, Your Honor. There's a lot more to this, and I'll be happy to, but based on your ruling, I think it should be done at this point in time, but I'll be happy to deal with the retaliatory question as it relates to the other side.
Okay, well, what happens is, why don't we do this, is it appears that there are no outstanding disputes in this matter, other than, as Mr. Lane brings up, the attorney fee issue. So what we'll do is I will, I guess, leave it open that any of the parties, if they have anything that post dates the September 25, 23 order, they can file a motion, and then we'll take that up at that time and have an evidentiary hearing if we need. But I guess I'll put this matter to rest at this point. Okay.
Thank you, Your Honor.
Thank you. Thank you all. We'll end this matter at 9:06 a.m. You're free to go. Have a good day.
You too, Judge.
You too, sir.
Oops. Oh, Ashley Smith, Kelly Johnson. Next case is Monroy versus Monroy. Please unmute. Calling case 2013-3547 DM Rose Monroy versus Roy Monroy. Today is Monday, December 18th, 2023 at 9:07 a.m.
Good morning to everyone. The court will note that the appearance of Ms. Smith on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for change in custody. Ms. Smith. You're muted, ma'am. You have to unmute.
Sorry, Your Honor. Yes, we are asking that an evidentiary hearing be had or that a temporary order be put in place based on the current circumstances after the last custody hearing. There has been verbal and emotional abuse by Mr. Monroy towards both Miss Columbia and the minor in question. There's also been threats, and Mr. Monroy has withheld the child from Miss Columbia during her parenting time. He recently withheld the child from her during the Thanksgiving holiday and has threatened to withhold the child from her during the Christmas holiday. We also have reason to believe that his home is overcrowded with children sleeping at the top of the stairs and with a relative sleeping in the laundry room. So the living environment is not particularly fit for a child. The child has also expressed issues with depression and thoughts of suicide based on kind of the environment and the living situation in Mr. Monroy's home. So we are requesting an evidentiary hearing to change what the current custody order is, and also a temporary order that would move the minor child to Miss Columbia until an evidentiary hearing is scheduled.
Okay, well, I'll tell you so that you know, for your edification, the court does not change custody on a temporary basis without an evidentiary hearing. So there'll be no temporary orders issued to that effect. Mr. Monroy, you have a response or?
Oh, yes, Your Honor.
Okay,
Recently in October, I had CPS come out to the house to okay it for my 2 young grandkids that were being taken by the state of Virginia. So I have currently them in my home due to CPS saying that it was more than enough of a livable area for them. My aunt has been staying here off and on. She's very sick. She has some lung issues, so she hasn't had her own place in some years, and the person she was living with died. So I let her come to my house till she can find a place, but she's my dad's blood sister, and like I said, she lives on oxygen, so I hate to see anything happen to her, but she's been in and out of the house. She doesn't just stay here, but you know, she stays at several places wherever they let her in, and I try to let her in because I hate to see anything happen to her. But outside of that, I work every day, you know, doing the same thing. A lot of the argumentative basis of the paperwork that was sent was the same thing she argued with last time: the forging, the supposedly, you know, CPS, the assaults or the battery. My daughter has never expressed to me not one time that she was suicidal, and I talked to her all the time. And when I talked to her about this situation, when I found out about it, she said she never said it, but you know, that's secondhand news, but you could ask her yourself.
Okay. Well, the court does note that many things have been alleged in this case, and many things that have been alleged would meet the Vadvarka threshold of proper cause or change in circumstances, at least sufficient for an evidentiary hearing. I don't know if they'll, again, carry the day as it relates to an evidentiary hearing, but at least they rise to that level to meet that threshold. So the court will schedule the matter for an evidentiary hearing. And I will tell you that in the meantime, the court expects that the orders will be followed. So if there are parenting time that's scheduled under the those particular judgments or orders, the court will enforce that. So I'll again assume and order that the parties comply with the current orders of the court. Yes.
I was going to say, the problem is she's using court papers from March of last year instead of the ones from when you had your final order, I believe was in June.
We go from the final order though. So
right, but she's not using that paperwork. I got her a copy and she wouldn't take it.
Oh, that's her problem then.
Right, that's what I said. So
if you're complying with the last order of the court, then that's all you have to do.
Thank you, Your Honor. That's what I am doing.
We'll contact the Ms. Smith, and Mr. Monroy will contact you and set a date for an evidentiary hearing in this matter. And but until then, just comply with the most recent order. Okay.
Thank you, Your Honor.
Thank you. Court will end this matter at 9:12 a.m. You're free to go. Have a good